A lot of people ask me, how do I not get sued over accessibility? And sometimes those people are designers, developers, and marketers. So let's talk through how to reduce your risk as a contractor or an agency. And on the screen with me, I have a document titled Developer and Designer Risk. And then the first bullet point is reducing risk is mostly intuitive. And it is. So, with your messaging, with your marketing, and with your contracts, you want to be clear and transparent. And you want to follow through on what you say you'll do. So, if you say you're going to do something, make sure you actually do it. And this next bullet point isn't intuitive, but in your contracts, I highly recommend that you specify adjacent, so nearby offerings that are not included. And what do I mean by nearby offerings? Well, you have your base offering, what you're actually providing. And if anything could be in the realm of that offering, you want to state whether or not that's included. So let's say with web design, let's say you're designing websites or you're designing a WordPress theme, whatever it is. You want to be completely transparent on what is provided in terms of accessibility. For example, if your design is not going to be fully WCAG 2.1 AA conformant, then you want to state that, not WCAG 2.1 AA conformant. What you don't want to do is try to play both sides. You either want to be 100% in or 100% out. And that is my next bullet point. So be aligned with what you do. And when it comes to accessibility, make it crystal clear whether you are providing accessibility or whether you are not providing accessibility. And if you don't want to provide accessibility, it doesn't mean that your product or your service is going to get discarded on the side of the highway, but you can simply say, we are not accessibility experts. However, we recommend this accessibility company or this accessibility consultant, etc., for accessibility. So here on this next bullet point, I have bring forward alignment with exactly what is and what isn't. So let's say you are offering accessibility services. Let's say you are auditing a let's just go with the website. The website is not fully conformant, so you don't want to state that the website is conformant. You don't want to give the client any indication that it's conformant unless there is 100% conformance and you know that with certainty. As another example, I have after remediation, these 5 issues are left. So commonly what happens is clients have third-party integrations that create accessibility issues. If those exist, don't give the client the impression that everything has been fixed. Instead, let them know exactly what remains. So just bring forward alignment. This is definitely not a situation where you want to finesse what actually the client is receiving, what the deliverable is, or what the state is of an accessibility asset. This next bullet point is very important because this is where I see the most risk being posed to agencies and to contractors and to just people who are offering marketing services. People are telling their clients, their audience, that an overlay widget will make their website ADA compliant or something else, WCAG conformant, whatever it is. That is risky, and that risk profile, by the way, is horrible. Just for commissions, just for a small percentage of commission, to put that kind of risk on yourself, never recommend a widget. Widgets are horrible. If you want to read more on this, go to overlayfactsheet.com. They don't make anything compliant. There's no such thing as automated compliance. There's in accessibility, I'm talking about. No such thing as automated compliance. No such thing as automated WCAG conformance. So I recommend that you stay out of the widget game altogether. It is very, very risky. And a written contract is a must. So with accessibility, with really anything, but with accessibility specifically, you want to have this in writing. And what I do is I not only have it in writing, I also communicate this to the client. This will also help you reduce your risk. This is a practical measure that is very effective in that you communicate effectively. So what you don't want to do is you don't want to talk around this and with the client. Let's say you're on a Zoom call with the client and you talk around accessibility and then you take a hardline stance in your contract. While that can potentially protect you, it also sends mixed messaging and it creates problems later. You want to be aligned verbally and with your contract, so make sure that you communicate to the client in multiple ways. I am very clear with clients over email, over calls, and with the contract exactly what they are and are not getting. And I never try to make the client feel better about anything. It's always going to be transparent and aligned with exactly what is. So that's a theme here in reducing your risk. And it's very intuitive and common sense if you think about it. It basically comes down to just being ethical and honest about what the client is getting. If you do this, you're going to greatly reduce your risk. And I have here also stay away from partial services. So you really don't. Today a client emailed me and asked me for a light audit. Well, what does a light audit actually mean? And so what the client is trying to do is they're looking for a lower price on an audit, but it's not like, I mean, if you could define a light audit for me, I would love to hear what a light audit actually is. It's either an audit or it's not. And so you may be offering services like reviews, or you may be, maybe you're even turning around and somehow offering some type of scan service. Whatever you do, make sure that it is completely clear and known what you are offering and not hazy or ambiguous. If you can't set out your offering in very concrete, tangible terms that are definitive, then you've got a problem with your offering. So I would stay away from the partial services. It's not to say that you can't offer them, but they can be potentially problematic, and it reduces or it increases your risk profile. And then on this next sentence, I have your widget commissions are a horrible risk profile. 20% commission for an ongoing significant risk. Yeah, I mean, it's ongoing. Your materials are out there. You just don't this is an alleyway you do not want to go down. All roads lead to horrible. Read overlayfactsheet.com, read overlayfalseclaims.com, and you'll see exactly what I'm talking about. You want to provide people, if you're going to have longevity, you have to have a solid foundation, and widgets are as an unstable as a foundation as you can have. So if the next part I have here is if you hold yourself out as an expert in some regard and tell website owners that you can make their website ADA compliant through using your widget, using your Shopify theme, or using your scan and remediation, then again, that's going to increase your risk, because now people are taking away, this is going to make my website ADA compliant, when in fact, it's not going to be. It wouldn't consider to be. Best practice for ADA compliance is to make your digital asset WCAG 2.1 AA conformant and publish an accessibility statement. That's not going to be the case with these different things. So you want to make sure you're aligned with best practices for ADA compliance. And so if your Shopify theme isn't fully conformant, if you don't let people know that even if it is conformant, that they can take it out of conformance, if you're telling them to use a certain widget, or if you're saying that a scan will make them ADA compliant, which we can go find examples of all of these right now on YouTube. I can go look at YouTube videos with thousands of views from channels with thousands of subscribers, and they're telling people the exact wrong thing because they got into this fast and they didn't research, or they're just going for the quick affiliate commissions. That is a horrible risk profile. I'm not going to go for a few $100s or a few $1,000s in affiliate commissions and then have this looming risk of being sued by someone who relied upon my promise as an expert, because that's the problem. When you hold yourself out as an expert, whether it's a legal expert, whether it's a design expert, a development expert, etc., a Shopify expert, and you're telling people, I know what I'm doing, right? That's what you're communicating. I know what I'm doing, but at the same time, you're giving horrible advice. That can come right back to you because people are relying on you for your expertise. And there are lawyers on YouTube, right, that are giving bad advice. They're recommending widgets because they don't know any better. There are Shopify experts. I know of examples off the top of my head. That is the reason I'm going through this. It happens. It happens all the time. There are people that will partner up or have partnered up with overlay widgets, and you don't want to go down that path. In fact, there are law firms, there are prestigious law firms that have partnered up with the wrong partner. Now they aren't recommending necessarily the products and services that could potentially lead clients to a lawsuit. But what they are doing is they are partnering up with someone that does offer those products and services. So you want to be aligned with what is and not as what is purported to be. Just because someone unilaterally bestows ADA compliance status upon their widget or their product, that doesn't make it so, right? And the of course, with website accessibility in the United States, we know this is an ultra litigious legal landscape, and we know that website owners are frequently sued over website accessibility. It is not just the big websites, it's not just the big companies, it is small businesses too. So for many different reasons, you want to make sure that you research this and you know what you're talking about. If you're going to hold yourself out as an expert and you're going to advise on ADA compliance or compliance with another law and accessibility, you want to make sure that you align your clients with what is the truth, what is the reality. And the reality is that you need to follow certain best practices. And really, if everything you do comes back to WCAG 2.1 AA conformance and you don't misstate how you get there, you're going to be in good shape. Of course, WCAG 2.2 is even better, but I haven't seen officially any law or regulation that has stated WCAG 2.2 conformance is necessary. Anyway, that's a side note. All right, so under the law, there's a concept, and it's referred to as detrimental reliance. So let's say we have a clear promise. I am an expert lawyer or SEO person or design or development agency, and I'm telling you that doing X will make your website ADA compliant and you won't get sued. So you being the expert, the website owner listening to you reasonably does X because you are the expert. The website owner then gets sued. The website owner settles that lawsuit for $10,000 and incurs $10,000 in costs to take care of all of the non-money settlement terms. Now the website owner goes back to you and sues you, the expert, because they relied to their detriment on your promises, on what you were claiming would make their website ADA compliant. This can happen to you, and this is a looming risk for many of the people out there who are, just the prime example, the most obvious example are the marketers who are telling people over and over again to use this widget, which they've white labeled or they're just a straight affiliate for. That is a bad risk profile I would not want. All right, so we're almost through the document here. A few more last notes, and this goes back to what I was stating earlier. Do not rely upon unilateral claims that aren't fundamentally sound. If there is a claim that a product or service will provide compliance or follows best practices for compliance, then it will be fundamentally sound. You can unravel that claim and go back to the source material being the law or the technical standards and you will find that the claim is well founded. But simply stating this makes this solution being thrown a word that is thrown around a lot. This solution provides ADA compliance. Okay, but how? That's what you need if you're looking at one of these um, anything. It doesn't have to be a magical solution. It could be any claim. You want to make sure that the claim is fundamentally sound. And so that's what I have next. Below, our widget is a solution for ADA compliance. Okay, you've told me your widget is a solution, but how is it a solution? Show me how. Show me the evidence. Show me the empirical data. Show me the information. So show me the citations that lead me down to the path of compliance or best practices for compliance. And that's what I have here next. Show me the underlying basis for your claim. And I've got claim misspelled. Let's see. So this isn't a weekend project, right? It's something where if you're going to offer accessibility services, then you want to make sure that you understand this and you've researched it through and through, and that you have a strong grasp of the material. The options here. Let's say you're a development agency. You can become an expert yourself, develop the expertise. You can hire an expert. You can source out the expertise, or you can partner with an expert. A lot of agencies, right? A lot of companies are looking to enter this space, and they're looking to enter quickly because they recognize the real potential with accessibility and compliance. Of course, as we talked about earlier, this is adjacent to many other industries. So SEO, although SEO and accessibility are really unrelated, they are in the same space. So it could be, when we're talking about SEO for websites, accessibility can go right along with SEO as being a service that a website owner is interested in. All right, and so those are your options. Again, no automated compliance solutions, quote unquote solutions. Solutions it's actually a positive word, but in the digital accessibility space, it ends up being a negative word because so many bad actors have used it to communicate that their widget does more than it does. Anything that's an overlay widget, anything that's an overlay, any automated remediation, any automated audit, stay away from it. And then last I have here overlayfactsheet.com and overlayfalseclaims.com. Read these websites. This is really good education if you are at all tempted by an overlay widget. Just start here and read these. And then something else I don't have on this I don't have on this document on the screen with me is digital accessibility and compliance. This is on Amazon. This is my book. This is how you get started. You understand the space. You understand what's going on. You align yourself with what is and not as what purported to be. You get the fundamentals. Once you get the fundamentals, then you can build your business from there. Then you can build out possibly an accessibility department or a wing of your existing agency or company. If you want to enter this space, you need to understand it. And what happens is a lot of people rush into this recognizing the immense potential, but they rush into this, and when they don't fully understand it, then it can give rise to risk. And so you really want to help people align themselves with the technical standards, because that's what material compliance comes down to. And so for the most part, right, when we look at compliance, the material aspect is accessibility. That's what this is supposed to be all about, is making sure that people with disabilities have access to digital experiences. So we want to make sure that we are meeting these technical standards, but then there's the compliance aspect of it. And the compliance aspect varies because obviously there are different laws and regulations. And then under Title III of the ADA, which is where most website owners are being sued with the ongoing serial litigation. Of course, there isn't a web rule that sets out exactly what we need to do to make our websites compliant with the Americans with Disabilities Act, but we already know the best practices here. So again, the best practices, WCAG 2.1, AA conformance, and then publishing an accessibility statement with one or more methods of contact. So now you have a much better understanding of how to reduce your risk. From here, it's just which option you choose, which path you go down, and then making sure you stay aligned with what is necessary to help your clients, to help your customers um, reach compliance. And if you want to be in this space at all, because there is risk that comes with this space, just given how, especially in the United States, how litigious website accessibility can be, but also how serious compliance is with all of the other laws and regulations that exist around the world. So this is a very serious space. Of course, there's also the fact that we want to ensure accessibility, and we want to ensure that the overarching purpose of all this is fulfilled, and that is to make sure that people with disabilities have access to our digital experiences. So that's why I rail against overlay widgets, because they don't do that. They just say they do. So I will include links to more resources in the description.